Well, thank you all for coming. This handout, I'll just tell you by way of general description, is not something that I'm going to read or follow or walk through, although I suspect it has everything in it someplace that I'm going to talk about. I will draw your attention to a couple of pages late in my comments, but what I'd like to do too is insist that if you have questions, either the topics that I'm addressing or other questions related to primarily Open Meetings Act is what brings us together tonight, say library law, then please don't hesitate to ask them, or if I don't see your hand or you're speaking, let's try to get my attention so that we can address those. I think that's going to be the most productive use of this time for you. Let me then further start by saying that if the Open Meetings Act was devoted to the topic, what I call the sexy topic of closed sessions, then we probably have only about 5 or 10 minutes tonight, because for libraries, that's really not a very important topic usually. You have a few closed sessions during the year, but unlike my school and city clients that meet regularly in closed session, virtually every week or a couple times every month, libraries just don't have that many occasions for closed sessions. Now that may sound like a good thing, and I'm digressing to say that's a horrible thing, because if you only do something a few times a year, it's a challenge to do it right. Cities and schools that maybe meet 30, 40, 50 times in closed session in a year ought to be doing it pretty well if they're doing it that frequently. But having started with that statement, let me back up and tell you why the Open Meetings Act, in my view and my experience, is so important, and that is because it is the pervasive importance. It is the statute that guides mostly all of your meetings, public and private or closed. And it's really, that's where I'm going to start with a discussion about the Open Meetings Act, is all of the other elements, rules, requirements that this statute gives us. Most of the rules relating to meetings are not in the library statute that you would pay attention to for other reasons. The Local Library Act that governs you as a city library has very little in it about meetings, okay? And most of the concerns and questions and answers are in the Open Meetings Act, even though, again, the closed session portion seems to attract people's attention. I use a phrase called the baggage of the Open Meetings Act, and I'll probably use it sometime tonight. So let me tell you what I mean by the baggage of the Open Meetings Act. It's the elements that are embedded or required when we talk about meetings. For instance, notice. Every meeting of the library is to have a notice of that meeting, with the possible exception, if you want to think of this as an exception, as an emergency meeting. That's one of the 4 types of meetings I'll talk about later. And the statute wants a notice of an emergency meeting, but by its very nature, the notice might be instantaneous, to the meeting. And the other example is what's called a reconvened meeting, where the notice is given at the meeting that then will be reconvened. And I'll talk more about the types of meetings later, but notice is the first piece of baggage. And a notice for regular and special meetings must be posted at least 48 hours prior. Now, many times our regular meetings are posted at the start of the year, so it's much more than 48 hours before. The notices must be posted at the principal office here at the library, which would be this facility. And if you ever have occasion to meet someplace else outside the principal office, the notice is to be posted at that location as well. You could meet elsewhere, and sometimes libraries do meet elsewhere, but if so, you have a notice posted both places. So anytime I'm talking about the baggage, item number 1 is the notice of the meeting. And item 2 is the agenda, but actually through our case law, the notice and agenda have really become merged. They're almost one thing now, because what the courts said in the what's called the Rice versus Adams County case is the agenda performs a notice function to the public. In other words, listing the items you're going to discuss or take action on. An agenda is required for the special meetings and required for the regular meetings. And I'll get into more of that later. But frequently now, the agenda is kind of the heading of, the notice is kind of the heading of what goes on into the agenda, and it's the whole thing is posted at the same time. So it's a little bit of a convergence of the two. But again, I think of those as the baggage. The third piece are the minutes. Every meeting you have is required to have minutes. And the minutes under the Act are defined, actually it's sort of shown as 3 pieces in the statute. I describe it as 4 pieces. The date, time, and place of the meeting is recorded in the minutes. The people present and absent, in the sense of the committee or the board that's absent, are noted in the minutes, or required to be noted in the minutes. And these are minutes of closed and minutes of open, both, any meeting. So you've got time, date, place, members present, members absent. Third thing is the summary of any matters discussed. A lot to be said about that. I'll get back to that third one in a minute, because the fourth one is a record of any vote taken. Now, I'll digress on that one first. I'm often asked, can we vote in closed session? And when the AG, the Attorney General, teaches the Open Meetings Act, for many years they've been basically teaching you can't vote in closed session. Now that's clearly wrong as a statement, but understand they do it because in an abundance of caution, they don't want folks to confuse what I'm going to talk about later. The final action must be in open session. In an abundance of caution, they try to avoid that mistake by saying don't vote at all. It's wrong, and the reason it's wrong is the very statute I just mentioned. If the minutes of closed sessions must include a record of any votes taken, and that's not a quote, but a very close paraphrase of the statute, then obviously you can vote in closed session. Why would you be required to have a record of it if you couldn't do it? Okay, it's simple English language. Let me go back to the summary of any matters discussed, because this is a common question or conundrum for folks. That's a direct quote of the statute, summary of any matters discussed. That varies in my clients from a one sentence to 40 pages. I've been talking only for about 8 minutes, and when I'm done in 3 hours, you could summarize this meeting or that part of this meeting as Lenzini talks about Open Meetings Act, right? That'd be a summary of that 8 minutes or 3 hours. Or we got to have a tape, but we could have a court reporter if you could find one and afford one anymore. They're fewer than we need. Taking down the transcription that would be probably about that long when we're done. That's a summary in a way. That's almost a verbatim, copy or transcription. Way too expensive to afford. And everywhere in between. Okay. As a lawyer, frankly, and especially avoiding unnecessary costs, use of taxpayer dollars, I prefer the shorter summary, adequate summary. I mean, we want it accurate, but we don't want to spend 40 pages when, a sentence or two will suffice. Now, again, a record of any vote taken is different than the summary of matters discussed. So I'd be happy to answer questions about that, but that's a common problem people have. I guess my first attention to the handout, one of two only, is if you look at the very next to last page and next to last page, you'll see a form.
So I'm going to ask, if I may.
Sure.
If you do take that vote in closed session, do you have to take the vote in open session immediately, or does it happen the next succeeding meeting?
Well, no, I can't answer it quite that way. There's no time connection. There's no timeline connection. What it depends on is what the vote was about in the context of an undefined term in the statute known as final action. A lot of times, libraries, it's their nature, I believe, take votes on things that are not final action. In fact, more often than not, their votes are not final action. I, as a lawyer, attend meetings where people will direct me to do something. You know, go out and get an appraisal. Go out and negotiate the best, offer or relationship with a former employee or whatever it might be. That's not final action. I have no authority other than what I'm directed to do, but it's to basically collect and bring back. Hopefully then that final action will be potential or possible. So in that case, it could be, days or weeks apart while I do my work and bring then the almost, I'm going to say, ripe decision for final action. So you really have to look at what's the vote about. Is it final action, or is it interim or a delegation of task is what I'll call it. Is that responsive? What I was trying to draw your attention there to was a form, it's now almost 20 years old, I guess. Minutes of Closed Session, or Closed Meeting is the title. And it's a 2-page form when it was originally written. And as you'll see, the second page is a summary listing of the reasons to go into closed session. But the first page is really to function as a checklist. Again, because libraries meet so seldom in closed session, they really need a checklist, in my opinion or my experience, so that they touch all the bases. So you'll see, and I've already summarized what the minutes are required to include, the 4 things as I described. So you'll see if you walk through the form and you answer the blanks, so to speak, the date, time, and place of the meeting, you will have complied with that requirement. The members present and absent, you'll have met the requirements. The vote on closing I didn't specifically talk about yet, but best practice, you have a recorded vote when you go into closed session. Best practice, you also denote the section of the statute that permits you to go into closed session. And I'll digress to say, I've listed on the next page the ones that libraries might use. I didn't put down the parole pardon board going into closed session because you don't have to worry about that. And there's, I think, 26 at last count, or whatever the full statutory list. These are just the ones that you as a library might use, so they'd be readily referenced. My favorite's 2C1. It's the basically the employment compensation discipline of employees. It's what most governments refer to as the personnel exemption. Now, honestly, it's not the only personnel. If you look at 2C1, 2, and 3, I think all 3 of them could be called personnel. 3 is the when you have a union, collective bargaining. That's certainly personnel related too. But normally what people mean when they refer to personnel is 2C1. I don't like to use personnel that often. I'd rather use the language of 2C1 if in fact that's what you're talking about. But there is a court case out of Southern Illinois a couple years ago that the objection was you couldn't use personnel as a reason to go into closed session, and the court said you're crazy. Of course you can use that. It's not a word in the statute. Read that. It doesn't say personnel. But we all know what that means. And so 2C1 has sort of been sanctified by that, at least that court, into personnel. 2C11's litigation and or pending litigation or probable imminent litigation. So that's there for reference. But now back to the checklist. You'll see a small portion there for the summary of matters discussed. You'll see a record of any vote taken and a warning note, so to speak, with respect to final action. So I commend that, or something like that, for your use for minutes of closed sessions to function, like I said, as a checklist, so to speak. Let me go to a different topic from a totally different perspective then. and I want to talk about what a meeting is. This facet of the diamond, so to speak. A meeting, first of all, until a couple years ago, it was easier to describe and to teach. A meeting was a three-part thing. Any gathering of a majority of a quorum of the body to discuss public business. Those were the three pieces, and that's almost a direct quote of the statute. Now, what's happened over time, any gathering has been sort of dealt with in a broadening sense. First big broadening about 10 years ago was a number of cases where people would attend technologically by telephone conference, actually was the first few cases. And the court said, that's fine. You can have gatherings electronically. It is a gathering, and that can constitute the meeting if you're a majority of a quorum and you're to discuss public business. That actually, though, has developed over time. And a lot of good lawyers, I was actually on the committee, I was the minority voice and maybe not the good lawyer, but other lawyers thought they ought to take the 5 or 6 cases that had established that and put it into the statute. Unfortunately, that was before we knew Springfield as a meat grinder, so they threw in a perfectly good draft bill that by the time it came out of Springfield, unfortunately was very contorted. It's called the electronic meeting statute about 5 years ago. It's the one that added some components that are really horrible for our use and utility, and as a result, we don't really have many electronic meetings, or at least like we used to or could have had. We've used technology to bar or hurt the disabled, the people that don't travel easily, that don't come to meetings physically when they could have gotten on their computer at home. We have many by video conference. We had examples of telephone attendance by visitors, not members, because we opened access electronically, technologically. And by the way, I'll digress to say, I don't know how many of you are in the private sector. I don't know if Gary's active in the Bar Association, but I attend meetings in Chicago remotely by phone weekly, and I don't have to spend 3 hours in the car going and coming and all the money that costs somebody by attending by telephone. So corporations and private groups frequently meet with technology. It saves money, saves time, increases attendance, doesn't decrease attendance. And unfortunately now in Illinois, the Open Meetings Act, we have some rules that are really unfortunate, in my opinion. One is you can't ever establish your quorum with electronic attending members. In other words, a quorum must be physically present. One might say, if you have a physical quorum present, why do you even need others to attend, right? You don't need them to make up your quorum. Secondly, the statute really gives the entity, the library, the right to permit others to attend electronically. And many cities have denied that right. I've got examples of people laying in a hospital bed, wanting to phone in to attend a meeting and be heard and vote and participate, and the cities say, no, you can't. If you can't physically make it here, you're not included. I've always thought of that as incongruous. If someone really wants to attend, I don't see why they're not let attend. So if you look at the model policies of electronic attendance for libraries, almost all libraries welcome attendance by electronics, not to make the quorum, the law doesn't permit that, but to participate and be heard otherwise. Secondly, the statute doesn't let just anybody electronically attend or even let everybody electronically attend. You can only electronically attend if you fit into one of 3 categories. One, what I call a note from your doctor. You have to have a medical reason for not being able to attend. That's one of the 3. 2, you have to have been displaced from the meeting by your employer, assuming you're employed. Your private business has sent you someplace. So you have to have a note from your employer, either a note from your doctor, I call it, a reason medically, or a note from your employer, a reason business-wise, or finally, out of the area of the meeting at the direction of the governmental unit. That's the best paraphrase I can use. As if, this is so idiotic, as if the library in DeKalb is paying one of you trustees to go to Florida. I know you don't get sent those missions by the library. So you're not likely to have a note from the library that has sent you out, and not able to attend the meeting. So but we have to fit in one of those three categories, or at least under the statute, you can't participate electronically. It's just idiotic. But that's the current state of our electronic gathering, okay? Majority of a quorum must be present. A quorum must be present. But that brings me to the prong of the definition of a meeting, to that majority of a quorum component. And first, let me use this as the reason to tell you, one of the biggest mistakes people make in the Open Meetings Act is they, like a horse with blinders on, they think it applies to the library board. Now, that's true, it does apply to the library board, but it also applies to any committee or subsidiary group, okay? So don't lose track of the application in other types of bodies. We don't have a lot of committees in libraries, but sometimes, finance committee or personnel committee might be composed either in your bylaws or ad hoc. And if so, your majority of a quorum of that entity, and don't forget the baggage I talked about, visited on the committee. So you may have a 3-person committee and a majority of a quorum's 2. And if that's finance, then a gathering of 2 of those people to discuss finance of the library triggers the Open Meetings Act, okay? And then, of course, the discussion of public business may sound like a fairly obvious component requirement, but I want to assure you that if some of you go to the same church, just because you gathered and there's a majority of a quorum there, and some may think, pick your religion, Islam, Catholicism is public business. It's not. We're talking about the library's business in this context. You can even get together if you wish, 5 or 6 of you, and discuss the merits of Sarah Palin. That may be public business, but again, it's not the library's public business. So this component for determining a meeting of us will be in the context of this body. If it's a finance committee, then it's library finance that applies for the discussion. If it's personnel, or if it's the board, it's library business, not DeKalb's business, or the U.S.'s business. Yes, ma'am.
Are those meetings closed meetings then?
No, so far I haven't made any distinction with respect to open or closed. The baggage applies basically across the board. The determination of whether we're having a meeting or not applies across the board. But I will talk about the distinction of open and closed several times here later. One other perspective, though, I'd like to shine on this. My experience with libraries is 99.9% motivated by how do we comply with the law, okay? Not how do we avoid complying with the law, is the best way I can describe that dichotomy. I won't say there aren't other governments someplace that care about that, but looking at it from the perspective that the gathering is telephonic, let's start with that one. If 3 of you leave tonight and you either get on the phone with each other or sequentially discuss whether you want to give D a raise, that's public business, right? Not that it can't be in closed session personnel. Don't get into that dichotomy if you don't mind yet. But some topic of public business discussed by a majority of a quorum gathering by the phone, you didn't have the baggage, right? We didn't have a notice of that. We probably don't have an agenda for that series of phone calls. We don't have minutes. That's the ultimate violation. In other words, you're illegally meeting. What I described, not here, but talk about many things at that church. But and there is a little bit of an appearance of impropriety, not so much at church or at social events, but a lot of my small villages, they break up the board meeting, they go to the local tavern or restaurant, and they have coffee. And we even caution them, look, you may be absolutely talking about baseball or something else, but be cautious and be careful because it's an appearance problem. Even though you're informed, educated, alert to Open Meetings Act requirements and violations, still give consideration to the fact that you're all, repetitively there. Split up or have others attend and, that can also witness that you only talked about, Jim Tomey's home runs or something, rather than the business of that village or library, okay? I want to zero in a little bit further, though, because we had then another more recent change when it comes to electronic attendance and gatherings. It was an effort to try to clarify more the use of computer contacts than phones. Phones are pretty obvious gathering. And I've lost track, I think it might have been 3 years ago now, certainly more than 2 years, that this amendment occurred that defines, I'm going to say electronic gathering, to mean instant messaging, chatting, electronic communications, and that's email, but the key phrase is interactive, contemporaneous interactive communication. So I'm kind of ask you to remember that phrase for a minute. Contemporaneous interactive communication. Now, that's almost certainly instant messaging and chatting, for those of you that do that sort of thing. It is not email, or not certainly email. I usually use the example because I have probably a couple thousand emails a day. If I send an email to the 9 board members, I'll guarantee you that a few of them will read it within minutes, either on a BlackBerry or their computer, or they're facing their computer. A few of them may read it tonight at midnight or tomorrow. And probably a few will never read it, or it'll be a long time before they ever read it. Okay? So if we're talking contemporaneous, we already have a problem, right? We have some that are contemporaneous. We don't really know if that's a minute or an hour, but it's, something fairly short order. Interactive means both ways. So it's not that I disseminate something by email. That's not enough. And by the way, I don't count, D doesn't count for open meetings because we're not on the board anyway. So if you let me be a board member just for a minute that I'm sending that email, that's not enough. That's a one-way dissemination. But the minute someone comes back, then I got some interactivity, right? But I don't know if I have a majority of a quorum yet. Because if I send an email to 9, that's one way, not enough. If I get an email back that's sent to all 9, then I've got a problem, right? Or even sent to 3. I've got a majority of a quorum involved with the interactivity. I discourage emails beyond the first dissemination, in other words. If D sends an email, I send an email, or a board member sends an email, like for instance, maybe your materials prior to a meeting, just like putting them in a hard copy mail or a hand delivery. There's nothing really wrong with that because it's not interactive, but don't hit that reply all button because then you have triggered the interactivity and probably the contemporaneous. What I cynically say, we'll never know until you're testifying 5 years from now. Because what happens 5 years from now? We'll have every email. It'll be printed out. We didn't know it at the day it happened or the week it happened, but I'll know it a year, 2 years, 5 years later. I'll have them all printed out, and it'll show me, the times and who it went to and who it came from and who it went back to, as well as the topics. And by then it's going to be way too late, right? We'll have either violated it or not violated it. You'll never know in time.